Oh, are we pleading any of these next cases, or?
Some of them, yes.
Not this one, Your Honor.
All right, Ms. Boyd, you have a $500 bond. I'm going to leave it at that amount. I am appointing the public defender to assist you. Good luck to you.
Say we just ask for a no return, Your Honor.
Oh, no return to the scene if you're released.
That's my dad's place.
Well, you were trespassed from there, so you can't return,
Okay, fine.
all right, at this time.
Yes, sir.
You can talk to your lawyer about changing that.
Okay.
Yeah, her emergency contact is the person who trespassed her. Is Lafferty, oh, is this Lafferty?
Yes, sir.
Okay. All right, Mr. Lafferty, you have a $250 bond. I will leave it at that amount. If you post the bond, you are not to return.
Your Honor, in this particular case, there was an offer to resolve.
Oh, I'm sorry.
The offer is an adjudication of guilt, 5 days in the Orange County Jail with credit, I believe, for 2. Is that correct? Okay. Court cost and no return to 5650 Hansley Avenue in Orlando, Florida.
Is that Hansley? H-A-N?
S-E-L, is that what you have? Hansel,
Oh,
sorry.
Hansel,
And
like
Ocoee.
Hansel and Gretel.
Yes.
Okay.
And, Miss,
I am-
you said you did, no?
I'm not going to do more damage.
Okay, well, now he's saying he doesn't want to, Your Honor.
All right.
So we'll keep it at 250.
Sir, you have a $250 bond. I'm going to stay it at that amount. If you post that bond, you may not return to the scene. I'm not going to take any action on the prior
Yes, sir.
trespass.
Yes, Your Honor.
Yes, Your Honor.
Ms. Borneman?
Yes.
All right, Ms. Borneman, you got picked up on a failure to appear warrant. The judge granted you a $500 bond on that, and I'm going to leave it at that amount.
Your Honor, there was an offer to resolve.
Oh, really? It said
Doesn't
not,
have an attorney, but, the offer was a withhold, no return. It's at 8863 West Colonial Drive in Orlando, Florida. Court costs.
It's Ocoee PD of 9174.
Oh, I didn't. Damn, I didn't speak with it. 9174.
9174.
Did you want to?
transient. I have no employment history.
Can you afford the money? I just need a second, Your Honor, 'cause I guess she was in a different cell. And Your Honor, as far as the costs are concerned, we would ask that you reduce to a civil lien.
Okay.
And Ms. Borman would like to accept and enter a plea of no contest.
Ms. Borneman, raise your right hand. Oh, well, sign that first. Okay, can you raise your right hand, please? You swear affirm everything you say today should be the truth, the whole truth, and nothing but the truth?
Yes.
All right, put your hand down. Ms. George tells me you wish to accept the state's offer and resolve this case today, is that correct? I've been handed a plea form, there's a signature on the bottom. I believe I just watched you sign it. Is that your signature?
Yes.
Did you read this form or go over it with Ms. George?
Yes.
Okay, and because you did that, you do understand that this is a criminal matter. You have a right to go to trial if you choose and force the state to prove that you did what you say, they say you did. You also have a right to an attorney. If you enter this plea today, the case is over today, and we're not having a trial, so you're giving up that right. And Ms. George did speak to you about the case. It's not quite the same as full representation, so I would consider that you're waiving your right to an attorney as well. Do you understand that by entering this plea today, you're giving up both of those rights to go to trial and to be represented? You understand you're waiving those?
Yes.
Okay. Can we get her a little closer to the microphone so we can get it? All right. Are you currently on probation for any other case?
No.
Are you under the influence of drugs or alcohol today?
No.
Have you ever been diagnosed with a mental illness?
No.
Did anybody threaten you, coerce you, tell you had no choice but to enter this plea?
No.
And finally, whether it applies to you or not, I just need to know if you understand that if you're not a U.S. citizen and you enter a plea to a criminal charge, you're subjecting yourself to deportation. Do you understand that concept?
Yes.
I'll find your pleas freely and voluntarily entered. You've knowingly and willingly waived your right to have a trial, and waived your right to be represented by a lawyer. I assume you're entering a plea of no contest, is that correct?
Yes.
I'll accept the plea of no contest. There's withhold, right?
Yes, Judge.
I'll withhold adjudication. Order you to pay your court costs, cost of prosecution, and $91.74 cost of investigation to the Coe Police Department. That all comes to $364.74. I will reduce that to a civil judgment. Also, you may not return to 8863 West Colonial Drive in Orlando, Florida. Do you have any questions about the plea you entered today?
No.
If you wish to appeal that sentence, you have to do it in writing in 30 days. If you cannot afford an attorney for the appeal, one will be appointed for you. This will resolve the case. Good luck to you.
Thank you.
Oh, she's to be released as to this case.
Thank you.
No, it was the other guy, Lafferty.
Ms. Pierce? Are you Ms. Pierce?
Yes, sir.
Okay. Ms. Pierce, okay, I don't see a plea form.
Defender at all.
Okay, well, you were picked up because you were supposed to be in court for something, and
No,
you,
sir, I was just in Polk County Jail.
okay,
They had a hold on me.
sir, that, or, I'm sorry, sir. That may be, and so it may have been issued in error. However, you'll have to file a motion with the court because it's already been, the warrant's been executed, the capia's been executed, so there's nothing to quash at this point. The judge did give you a $2,000 bond. I'm gonna leave it at that. You can post that and be released. If you feel that you'd like to change that, you can ask your lawyer to file a motion in your case. All right? $2,000 bond. Good luck to you.
Thank you so much. I'm confused. What do I do? I know, but. I can get out today.
Not today.
When will I get out?
You either post the form, or I'm gonna try to get you in front of the court to explain you're in Polk County.
Yes, ma'am. When will my next court date be? When? Call me.
Today.
Call me on.
On the blue box.
Ma'am, can I speak with my family?
Yeah, call me on the phone when you get downstairs.
Mr. Watkins?
Yes, sir.
All right, Mr. Watkins, you failed to appear in 22 MO 897. You have a $500 bond. Oh, is this pleading?
Yes, Your Honor.
Is he pleading to both the MO 897 and the MO 1168?
Yes, Your Honor.
Okay.
It's an adjudication of guilt, credit time served, and court costs. Is there a filing fee? I believe there's a $10 filing fee.
On the 897.
Yes, and a $10 filing fee, Your Honor.
So is he getting hit with the 233 on the 897 and the 223 on the 1168?
Yes, Judge. However, given that he's transient, so he has no objection to,
Well, it
being
says
as a
he's
civil
working
lien.
just under the table. All right, well, without objection. All right, thank you. All right, Mr. Watkins, can you raise your right hand, please? You swear or affirm everything you say today should be the truth, the whole truth, and nothing but the truth? All right, put your hand down. Sir, I'm told that you wish to accept the state's offer in these two cases, enter a plea and resolve them today. Is that correct?
Mm-hmm.
I've been handed a plea form, sir. There's a signature down here on the bottom. Is that yours?
Yeah.
Did you read this form or go over it with Ms. George?
And didn't hear you correctly.
He said he didn't hear you, Your Honor.
This form that you signed, did you talk about it with Ms. George briefly? Okay. And did you understand the conversation you had with her?
Mm-hmm.
So you do realize that although these are municipal ordinance charges, they're treated as second-degree misdemeanors. And that means that you have every right to go to trial if you choose and force the state to prove that you did what they say you did. However, because you're going to enter a plea today in both cases, we're not going to have a trial. The cases will be over today. And so you're giving up the right to have a trial by entering this plea. Do you understand that?
Yes, sir.
All right. You also have a right to be represented by a lawyer, and Ms. George has been kind enough to speak to you about this. It's not really the same as being represented in full, so I would treat that as waiving your right to be represented. Do you understand by entering this plea, you're giving up your right to an attorney as well?
Yeah.
Are you currently on probation for any other case?
No.
Are you under the influence of drugs or alcohol today?
No.
Have you ever been diagnosed with a mental illness?
No.
Did anybody threaten you, coerce you, or tell you you have no choice but to enter this plea?
No.
And finally, whether it applies to you or not, do you understand the idea that if you're not a U.S. citizen and you enter a plea to a criminal charge, you're subjecting yourself to deportation? I'll find your pleas are freely and voluntarily entered. You've knowingly and willingly waived your right to have a trial, waived your right to be represented by a lawyer. I assume you're entering pleas of no contest because you just want to resolve these. Is that correct?
Yes, sir.
I'll accept the pleas of no contest in each case. I'll adjudicate you guilty. How many days?
For the failure to appear, 4 days, and the new charge, 2 days.
Okay, so in 22 MO 897AO, I'll sentence you to 4 days in Orange County Jail. I'll give you credit for the 4 days you've already done. In 22 MO 11688O, I'll sentence you to 2 days in Orange County Jail. I'll give you credit for the 2 days you've already done. He is to be released as to both of these cases. I'll order you to pay your, I forget what they call it, but the filing fee and the other thing is is $233 in the 897 case and $223 in the 1168 case. That comes to $456. I will reduce those costs to a civil judgment. Sir, do you have any question about the pleas you entered today? Do you have any questions about what you did today?
No.
If you wish to appeal either sentence, you must do it in writing in 30 days. If you cannot afford an attorney for the appeal, one will be appointed for you. This will resolve both cases. Good luck to you. Okay, looks like we're doing arraignments.
Oh,
Your Honor, this is Mr. Grant Sutton.
Okay, are any of the arraignments pleading, or are we just resetting them?
Your Honor, Grant Sutton, we're gonna enter a denial.
Division 61 VOP status will be November 1st at 10 o'clock in courtroom 7C.
Okay. Sergeant?
We are not pleading, Your Honor. We're just gonna enter a plea of not guilty.
Okay, have you been appointed yet?
I don't see an attorney.
It doesn't say here, so.
She does have 2 cases, Your Honor.
Oh, I only have one.
She has 5006 and 6020.
What's the other one?
She has the 22CF 5006 or CT, and then she has 22MM 6020. They're separated within the document.
Oh, yes, we're gonna enter a plea of not guilty as to both, Your Honor, if you'll point. I don't see.
Yeah, I'll point to PD. I don't see the other one, but,
It's, in the staff, Your Honor. It's just further.
Page 7.
It's number 7 on our page.
are you Miss Sargent?
Yes, sir.
All right, Miss Sargent, I got it. Okay. So you have two cases. 22 CT 5006 AO and 22 MM 6020 AO. Are these from the same event?
I believe so, Your Honor.
Ian, can I combine these in one division now, or? Typically at arraignments, we'll put them in the same division, but, well, all right, I don't want to make more work, so, I'm going to appoint the public defender in each case. We're going to enter a plea of not guilty in each case. So the 22 CT 5006 AO is in 61, my division. PTC would be when?
November 21st at 9 o'clock in courtroom 7C.
Okay, and the 22 MM 6020 AO is an 85, so PTC would be,
November 7th at 9 o'clock in courtroom 4A.
all right. Ms. George, I don't know if you might want to reach out to whoever's the PD and see if they'll consolidate them.
Okay. That's your next court.
All right, Barton's got 48 days in on a resisting.
Yes, Your Honor, the issue is that he has an eval pending the 4th of November for competency, so.
Are we worried that if he's gone, he won't be found?
No, we don't have that concern, it's just that I can't fleet him, due to the.
Okay,
eval pending.
And it did come in with several other charges.
all right, so are we entering plea of not guilty?
Yes, Your Honor.
All right, PD's already appointed, not guilty, pretrial in 81 would be?
December 2nd at 9 o'clock in courtroom 6B.
All right, sir, it's your next court date, get in touch with your lawyer. Mr. Hamilton? All right,
We're gonna enter a plea of not guilty, Your Honor.
okay, 28 days on a trespass.
There's no, offer, I believe it's a true victim, is that correct?
It came in as a Burke structure, I believe, Your Honor. So there's a true victim that I believe wanted to be
All
present.
right, pretrial conference for 62.
December 15th at 8:30.
All right, sir, get in touch with your lawyer.
How many days, Your Honor, did you say?
This says he's got 28 in.
Okay, I'm gonna let the attorney.
Jarvis?
Yes, sir.
All right, this is a VOP, PD represents, what are we doing?
Denial, Your Honor.
All right. Enter a denial, we need a VOP day in 62.
December 12th at 8:30 in courtroom 12C.
It'd be good if we could set it for noon, it'd be 12, 12 at 12 and 12. Mason?
Yes.
We're gonna enter, I'm a not guilty, Your Honor.
Okay, PTC in 50.
November 18th at 9 o'clock in courtroom 4E.
Bryce Abayomi?
We're gonna enter a plea of not guilty, Your Honor. She also has the eval pending.
All right, PTC in 84.
November 9th at 8:45 in courtroom 4B.
Is that it?
Mr. Sparks didn't show up for his notice to appear.
Can we do that?
Yes, ma'am.
Is there anything I can say to? As far, yeah. As far as what?
How many Your Honor, how many days does she have?
Sheet says 27. 2 days surety, 25 days after her bond was revoked. Mr. Sparks?
Yes, Your Honor.
In Mr. Sparks' case, Your Honor, the offer from the state is an adjudication of guilt, credit, time served, and court costs. Mr. Sparks would like to accept and enter plea of no contest.
No, I don't.
Oh, I thought you said yes.
I did not. You did not ask me.
Sir, well, then he's gonna enter. I did. Oh,
Not guilty?
not guilty.
Okay, pretrial in 82, please.
November 9th at 1:30 in courtroom 9B.
Thank you, Your Honor.
All right. Mr. Thomas?
And, we're gonna enter a denial, Your Honor.
All right, now VOP date in 50.
November 14th at 9 o'clock in courtroom 4E. So all three cases.
Oh, yeah, he's got. All three are. Oh, well, that's convenient. They're all in 50. Okay, that's it for Remus.
Oh, we're done with the remix.
You, Mr. Evans?
Yes, sir.
All right, Mr. Evans, you have a $500 bond. Post that bond, you to have no contact with any victim and no return to the scene.
Yes, sir.
Mr. Hayes, you've, was there, I've got 3 counts here. They're all under the same case number though, right, Ms. Fleming?
2 cases.
Yes, Your Honor, I have 2. I have the resisting and the paraphernalia under the 7084, and then the disorderly separate.
Okay. All right, so, sir, you have a $500 bond on count 1, 100 on count 2, 250 on count 3.
Your Honor, the offer from the state was an adjudication of.
Oh, I'm sorry, is this a plea? Plea?
Yes, it's an adjudication of guilt, credit time served as to both, charges.
This is disorderly conduct.
I don't have the, case number.
22 MO 1164.
And Your Honor, since he's on Social Security, I would ask that you reduce the, court costs. The civil judgment.
So, in 22, oh no, that's MM, never mind. So that's, we're including the disorderly?
Yes, Your Honor, it's an adjudication on both.
All right. All right, Mr. Hayes, can you raise your right hand? Do you swear or affirm everything you say today should be the truth, the whole truth, and nothing but the truth? All right. Sir, I'm told you wish to accept the offers from the state/city and resolve this case today. Is that correct?
Sir.
Sorry?
Yes, sir. Yes. Yes, sir.
Yes, okay. Sir, I've been handed a plea form. There's a name written on the bottom. Is that yours? Is that your signature?
Yes, sir.
Okay. Did you go over this form with Ms. George? The lady standing
One you just signed.
next to you?
Yes, sir.
Okay. Did you understand what's in it?
Yes, sir.
Okay, so you do realize that the first case is a misdemeanor charge. The second case is a Sydney ordinance, but it's treated as a second-degree misdemeanor. This means that you're entitled to have a jury trial in all of these cases and force the state or city to prove that you did what they say you did. But because you're gonna enter this plea today, the case will be over today, and we're not having a trial, so you're giving up that right. Do you understand? You're waiving your right.
Yes, sir.
You also have a right to be represented by an attorney, and Ms. George was kind enough to speak to you today, but it's not the same as full representation. So, you understand you're giving up your right to be represented by a lawyer by entering this plea.
Yes, sir.
Are you on probation for any other case?
No, sir.
Are you under the influence of drugs or alcohol today?
No, sir.
Have you ever been diagnosed with a mental illness?
No, no, sir.
Was that no?
No, sir.
Okay.
Just speak slow.
Okay. Did anybody threaten you, coerce you, or tell you that you had no choice but to enter this plea, or these pleas?
No, sir.
And finally, sir, whether it applies to you or not, do you understand that if you're not a U.S. citizen and you enter a plea to a criminal charge, you're subjecting yourself to deportation?
Yes, sir.
I'll find your pleas are freely and voluntarily entered. You knowingly and willingly waived your right to have a trial, waived your right to be represented by a lawyer. I assume you're entering a plea of no contest in each case. Is that correct? You just want to resolve them?
Yes, sir.
I'll accept your pleas of no contest in 22 MM 708480. Oh, it's credit time served. How many days in?
2 days.
2. I'll adjudicate you guilty. In that case, order you to serve 2 days in Orange County Jail. I'll give you credit for the 2 days you've already done. You're to be released as to that case. In 22 MO 116480, I'll accept your plea of no contest. I'll adjudicate you guilty of that. Order you to serve 2 days in Orange County Jail. Give you credit for the 2 days you've already done. You're to be released on that case as well. Your court costs, cost prosecution, et cetera, comes to $496. I will reduce that to a civil judgment. Sir, do you have any questions about the pleas you entered today? Do you have any questions about what you did today?
No, sir.
All right, if you wish to appeal the sentences, you must do so in writing in 30 days. If you can't afford an attorney for the appeal, one will be appointed for you. This will resolve both cases. Good luck to you. Jones pleading or not?
No.
Okay, sir, in 22 MM 708980, you have a $500 bond. I'm gonna leave it at that amount. And then you were also picked up on a violation of probation, or I guess that's an on-view. You're not entitled to a bond on that, and I'm not granting one. You will have to seek release from the judge on that case. Good luck to you. Mr. Landers,
Mr. Landers is currently on mental health status, Your Honor.
waiving.
My name, sir?
No, not.
I'm sorry.
Okay. Okay, can we, reset for tomorrow? There is an offer to resolve, Your Honor.
Okay, we'll reset. Landers, Richards,
Is bonded, Your Honor.
okay. Hopkins,
Yes, sir. Good morning, Judge.
good morning. All right. Is this, okay, you're just filling out that form. All right, Mr. Hopkins, you failed to appear You have a $500 bond, which the judge indicated on the capias. I'm gonna stay that.
Can I resolve it today, sir?
Not unless there's an offer, and my understanding is there is not. All right, Mr. Hunt. Mr. Hunt.
Your Honor, this is the case, I talked to Ms. George about this one. He's here for an open container, which state did convey an offer on, and adjudication credit time served. However, he's also here on a failure to appear on a resisting. I do believe it's within your division. When I looked up that case, I did not see a NTA or an information filed, so I'm not entirely positive how he has a failure to appear, as I don't see a NTA or an information filed.
Do you have the sheets on Hunt?
However, it is in your division, Your Honor, so I didn't know if you had some inside knowledge. I believe he was prematurely set for arraignment, and he failed to appear at that arraignment, and that's where the KPS came from.
Well, I am pretty good about checking for notice, and if you didn't have any, I'd be shocked if I issued it. Not saying I didn't. Oh, I did issue it. Okay, so 750, he posted a bond in this case, so my guess is the bond had the correct information. Why can't I find it?
No, I don't have anything either.
There we go. Yep. When he bonded out, in this case, he signed for his bond paperwork that said he was to be in court on September 6th, 2022 at 1 p.m. So, he had notice. He didn't appear. If he didn't have notice, I wouldn't have issued a warrant, but he did. And the original bond was 500, which is why I set it at 750.
Well, the state can't convey an offer at this time because there's no info or NTA. So I don't know why he was set for an arraignment, as there's no NTA or information. So I can't.
That's a valid question. I really
That's the
don't
main
have an
issue,
answer
Your Honor.
for you.
And
And it hasn't been filed on, right?
No, Your Honor. I don't see a traffic ticket, I don't see an NTA, and I do not see an information.
What's a resisting?
Mhm.
Why would there be a ticket?
I was looking for any possible charging document of any kind. Trying to be,
You were trying to, yes. give him the
trying to find
benefit of
something.
the doubt.
of that, Your Honor, I would ask for an ROR, at least on the failure to appear, being that we can't resolve, there's no information filed. But he would like to resolve the new law violation.
State has no objection, Your Honor.
It's a
Given-
crap charge to begin with.
Given that it's your KPS, you can change it, so state has no objection to an ROR on the 5103.
Of course, I can't really dismiss because there's no case yet. All right. So he's entering a plea in 22 MO 1165
Yes, Your Honor.
AO. All right, Mr. Hunt, you raise your right hand. Do you swear or affirm everything you say today should be the truth, the whole truth, nothing but the truth?
Yes, sir.
All right. All right, I'm told that you want to accept the offer in the new case, the open container, and resolve the case. Is that correct? Yes. I have a plea form, sir. There's a signature on the bottom. Is that yours?
Yes.
Did you read the form?
Yes, Your Honor.
Understand the form?
Yes, Your Honor.
Any questions about this form? All right, because you read and understood the form, you understand that this is it's treated as a second-degree misdemeanor. You have every right to go to trial, see if the state can, or city, I guess, could prove, or county, could prove that you did what they say you did, but if you enter this plea, the case is over, and we're not having a trial, so you're giving up your right to a trial. Do you understand that?
Yes, Your Honor.
You also have a right to be represented by a lawyer, and although Ms. George has been kind enough to speak to you about the case, it's not the same as full representation, so I would treat it as you waiving your right to a lawyer as well. Do you understand you're waiving that right?
Yes, Your Honor.
Are you currently on probation for any other case? Are you under the influence of drugs or alcohol today? Have you ever been diagnosed with a mental illness? No?
No, Your Honor.
Okay. Did anybody threaten you, coerce you, tell you had no choice but to enter this plea?
No, Your Honor.
And finally, whether it applies to you or not, do you understand that if you're not a U.S. citizen and you enter a plea to a criminal charge, you're subjecting yourself to deportation?
Yes, Your Honor.
All right, I'll find your plea is freely and voluntarily entered. You've knowingly and willingly waived your right to a trial, waived your right to a lawyer. I assume you're entering plea of no contest, meaning you want to resolve it, right?
Yes, Your Honor.
All right, I will accept the plea of no contest. I'll adjudicate you guilty of the charge. Is it 2 days, Ms. Keys?
Yes, sir.
Huh?
Yes, 2 days.
2 days. All right, I'll sentence you to 2 days in the Orange County Jail. I'll give you credit for the 2 days you've already done. He's to be released as to this case. Your court costs come to $223. Did you ask me to reduce? No. All right, $223. If I give you 6 months to pay, is that enough time?
Yes, Your Honor.
6 months to pay it. You have any questions about the plea you entered today?
No, Your Honor.
If you wish to appeal that sentence, you have to do it in writing in 30 days. If you cannot afford an attorney for the appeal, one will be appointed for you. In case number 22 MM 5103 AO, sir, I'm assuming you listened to the conversation between myself and the state, and it is my case, and you got set for arraignment. Whether you should have or shouldn't is debatable, but you did get set, and you did not appear, so what I typically do is look to see if the person had notice and knew they were supposed to be there. And the bond paperwork that you signed for when you left the jail told you you were supposed to be in court on September 6th at 1 o'clock, and you weren't there. And so since you had notice and you didn't show, that's why I issued the capias. And the reason I put 750 is because your original bond was 500. Typically up it, when we've given you one shot and you missed. And today I reviewed the arrest affidavit. I do think it's, I'll leave my personal opinions about the case out of it. But the state hasn't filed on this, so there's nothing I can do. It doesn't exist as a legal entity. But I will do this, because this is how I typically handle cases in my division. If a case comes up for arraignment and it hasn't been filed, I set it for a pretrial date. If the state still hasn't filed by that pretrial date, I abate it, because I'm not going to keep hauling you back to court if the state can't make up their mind. I want you to, and I'm gonna do that today. I'm gonna abate the other case, I'm gonna give you ROR on that case and abate it. But I want you to understand, that doesn't mean that the state can't file on it. They have up to a year on a second and 2 years on a first-degree misdemeanor. So what it does mean is if they do decide to file on this, they'll have to issue a summons and find you. A deputy will walk up to you someday, somewhere and say, hey, you got a court date. And if you don't show up, then you might get a warrant for your arrest. But since we already hauled you to court twice and I arrested you for not showing up, and the state still hasn't done anything, okay? I'm gonna abate that case. So there will be no further court dates unless you receive a summons. Clear?
Clear.
All right. ROR, I'm on the other case. Abate it, please. And the other case, we're done.
Thank you, Your Honor.
Yeah, ROR and then abate. Thomas?
Yes, sir.
Are we doing anything on this or no?
No, Your Honor.
All right, sir, you actually have two, wait, I'm only addressing the misdemeanor, the 22 705280. You got picked up on a warrant for petty theft. There's a $500 bond on that warrant. I will leave it at 500. Good luck to you. All right, Mr. Warren, in case number 22 313280, you failed to appear. The judge issued a capias with no bond. I'm gonna leave it at no bond. You will have to seek release from the judge on that case. Bracero, are you Bracero? All right, Mr. Bracero, looks like there's a plea form showing up. Ms. Fleming, didn't we used to call these the sundown laws?
I believe so, yes.
Didn't we all agree those were not a good thing?
Still on the books, Your Honor?
Just saying. You know what a sundown law is, right? You gotta be out of town by sundown. It only applied to certain people.
And the offer from the state is a withhold of adjudication and court costs, Your Honor. No return, do you have that? I forgot to put that.
Can't go back to the park?
650 Santiago Avenue.
What is it, 650?
Santiago Avenue.
And we'd like to accept an enter plea of no contest, Your Honor.
Is that Orlando, Florida?
Yes, Judge.
Okay, it says he's got a holdout out of Osceola County. Does he know he's not going?
Yes, he has a bond.
Oh, so he can post it, okay. Oh, shoot, I didn't write the case number.
No, I don't have.
Ms. Fleming, do you have it? Oh, Ann has it. One, 166. Oh, thank you. All right, Mr. Bracero, my understanding is you wish to accept the state's offer and resolve this case today, correct?
Correct.
All right, raise your right hand, I'm sorry. Do you swear or affirm everything you say today should be the truth, the whole truth, and nothing but the truth? All right, put your hand down. I have a plea form in my hand. There's a signature on the bottom. Is that yours?
Correct.
Did you read the form or go over it with Ms. George? You didn't talk to Ms. George about it? Okay, the top half of this form explains to you that this is, even though it's a municipal ordinance, it's treated as a second-degree misdemeanor. And that means, if you wish, you can force the state to have a trial in front of a jury, see if they can prove you did what they say you did. But if you enter this plea today, the case is going to be over today and we're not having a trial. That means you're giving up that right by entering this plea. Do you understand you're doing that? Okay, it also says that you have a right to be represented by an attorney. And even though Ms. George has been kind enough to speak to you, it's not the same as full representation. And so I would treat it as you waiving your right to a lawyer as well. Do you understand you're waiving your right to a lawyer by entering this plea?
Yes.
All right. The bottom half of that form asks you various questions, including, are you currently, well, I don't know if it asks this, are you currently on probation for any other case? No. Are you under the influence of drugs or alcohol today? Have you ever been diagnosed with a mental illness?
Yes.
Is it something that impairs your ability to understand what you're doing today? So you are thinking clearly, and this is what you want to do, correct?
Yes.
All right. Did anybody threaten you, coerce you, or tell you you've got no choice but to enter this plea? And finally, whether it applies to you or not, I just need to know that you get the idea that if you're not a U.S. citizen, entering a plea to a criminal charge would subject you to deportation. You understand that concept? All right. So that's basically what this form says. Do you feel that you understand those things we discussed? All right. I will find that your plea is freely and voluntarily entered. You've knowingly and willingly waived your right to have a trial, waived your right to be represented by a lawyer. I assume you're entering a plea of no contest, meaning you just want to resolve this. Is that right? All right. I'll accept your plea of no contest. I'll withhold adjudication, ordered you to pay your court costs of $223. If I gave you 6 months to pay, is that enough?
Yeah.
6 months to pay. Do you have any questions about the plea you entered today? If you wish to appeal that sentence, you have to do it in writing in 30 days. If you cannot afford an attorney for the appeal, one will be appointed for you. You are to be released as to this case, and you do have a hold out of Osceola County, which I'm sure you're aware of, but apparently you have a bond that you can post. Good luck to you. Mr. Hines?
And there is none.
Sorry?
We're not resolving this one, no.
Okay, so am I doing so the new case is 22 MO 1167AO, the open container. Did that, all right. I didn't put a note as to whether it came in with a bond, so I'll give you a bond of $100 on that. Am I addressing the VOP?
Yes, Judge.
Okay, so the VOP, you're not entitled to a bond on that, and I'm not gonna grant you one, sir. You're gonna have to seek release from the judge on that case to get released. I will not I'm not gonna take any action on the his two prior cases. I don't find them sufficiently related, although I guess the cocaine could tangentially. All right, Zimmerman.
Zimmerman is currently on mental health status, Your Honor.
And there's an offer to resolve. Can we reset for tomorrow, Your Honor?
Reset Zimmerman. Mr. Black?
Yes, sir.
All right, Mr. Black, you have bonds in this case of 15,000 on count one, 1,000 on count two, 1,000 on count three. I'm gonna leave those bonds at those amounts. I am also going to revoke your release in 2021 CF 3219BO. I am appointing the public defender to represent you. Good luck to you. Mr. Blevins? Sir, you qualify for release under, on the pretrial release program. I'll grant that. I'll release you on that program. You don't have to post a bond, you have to follow their rules. However, part of their rules are gonna be that you have no alcohol or illegal drugs, and you'll be subject to random urinalysis while this case is pending. I am appointing the public defender to assist you. Good luck to you.
We have, the 30-day grace.
Oh, yeah. They won't test you for the first 30 days, or I guess they won't. So clean out. Drink a lot of water. So I'm heard, so I've been told. Mr. Volkus?
Focus is currently on behavior status, Your Honor.
Defense will waive them.
All right, it came in on count one was, wait,
Count one came in at no bond.
but it's not PBL, right?
It's not, Your Honor, it's an F2, so he is entitled to a bond.
Yeah, so my note was I was gonna give him a $7,500 bond. He's got 100 on count two and 150 on count three. I'll stay those. No weapons, no firearms, no contact with any victim, no return to the scene. And I am gonna revoke on 20, you did waive, right?
I did waive, I was just gonna point out that he's in comp proceedings, Your Honor.
Yeah, he probably is. So I'm gonna revoke on 22 CF 10351 AO. And hope he gets help. Kirby, all right, Mr. Kirby, you, arrested on a warrant, failure to appear in case number 22 CF 3176 AO. You do not have, a bond on that warrant, you'll have to seek release from the judge on that case. Ms. Fleming or Ms. George, if this is Dean. Oh, he did? Oh, okay, well, that answers my question. Dulaire?
Yes, sir.
All right, Mr. Delaire, you have, in case number 22 CF 12145, you have a $1,000 bond on each count. I will stay those bonds, and I'm not gonna take any action on 22 CF 730280. I don't find it sufficiently related. Good luck to you.
Yes, sir. Thank you.
Ms. Fleming,
Yes, Judge.
is count one PBO?
No, Judge. He's entitled to a bond.
Okay.
It's an F2. Both counts are F2s.
All right. Mr. Etheridge, sir, I'm gonna grant your bond, in this case, on count one of 5,000, and I think it came in with 5 on count two. I'm gonna stay that. If you do post those bonds, you have no contact with any victim and no return to the scene. And I'm appointing the public defender to assist you. Good luck.
Yeah, it has no weapons.
There's
As what?
No weapons?
Oh, yeah, oh, I'm sorry, yeah, no, can't possess any weapons or firearms while you're on this case is pending. If you have any, you must surrender within 24 hours. Thank you. All right, this one I did have a question on. It came in at 10.
Yeah, sure. Count one is a first degree felony that is punishable by life. So say it's asking that you set
Yeah.
that one at no bond and set it bond on count two, which is an F3.
Okay, good, that's what I was planning to do. Also, I'm guessing no contact with co-defendant Isaac Daniels?
Yes, please, Judge.
All right, Mr. Frisora Ramos?
Yes, sir.
I don't know if I got that right. All right, sir, in case number 22 CF 1216, is that 6 or 8? 83 AO, and count one, that count, although that came in with a $10,000 bond, that is punishable by life, and because it is, you are not entitled to a bond under Florida law, so I'm revoking that $10,000 bond and putting it at 0. You can seek release from the judge on the case, but you'll have to do it with that judge, and you had a $10,000 bond on count two, and I'm gonna stay that at 10,000. Now, if you are released, in the future, you will have no contact whatsoever with any alleged victim. You will possess no weapons, no firearms. Any in your possession must be surrendered within 24 hours of your release. And you are to have no contact with any co-defendant.
Yes, sir.
Your Honor, state would also ask for a no return to the Family Dollar.
Didn't I say no return?
I believe you said no contact and no weapons.
Oh, sorry. And no return to the Family Dollar.
Sir.
Okay. Mr. Gray? Hi, Mr. Gray. In okay, two different cases. So in 22 CF 12191 AO, we have a $5,000 bond. I'm gonna stay that. In 22 CF 9971 AO, you have a $4,000 bond. I will stay that. State, I wasn't gonna take any action on the other cases. They're not really sufficiently related. State want to be heard on that or not?
One second, Your Honor, I'm just checking to make sure there wasn't.
It was theft of a motor vehicle, resisting, and grand theft.
I'm just
These
making
are-
sure there wasn't a firearm located that we just didn't charge. No, state will leave it within your discretion.
I'm sorry, what?
State will leave it within your discretion. I didn't see a firearm located in any
All
of the
right,
other two
and
cases.
I'm gonna find they're not sufficiently related. I'm not gonna take any action in the other cases. So, sir, you got 5,000, 4,000. Good luck to you. Ms. Green? All right, Ms. Green, you were picked up on a warrant. You have a $150 bond on each count. In
State
case,
would request that you increase the bond. She is currently on probation for also grand theft and uttering a forged instrument ×3, fraud use of personal ID ×2, theft, unauthorized use of a DL. And these are basically the exact same charges.
I have to say, when I looked at the warrant,
It seems,
kind of shook my head. I'm like, man, these are felony charges.
it seems incredibly low, given her history and given the degree of felony they all are.
So I believe, well, all I can do is speculate, but Your Honor, the only reason I believe that they set it so low is because she has this hold out of Palm Beach at 0 bond. She's gonna have to post the bond here in order for her to be transported to Palm Beach to deal with whatever issues.
Judge wouldn't have been aware, if it came in on an affidavit for a warrant, the judge wouldn't have known about the other one. My guess is whoever did it intended to put a higher amount on count 1 and then 150 on all the subsequent. And might have even meant to put 1,500 on count 1 and then 150 on everything else and somehow left a 0 off.
Yes, Your Honor, that's.
That makes more sense to me. So I will increase the bond on count 1 to 1,500. I'll leave the remaining counts at 150. I am appointing the public defender to assist you, and as you seem to be well aware, you do have a hold from Palm Beach, so even if you post those, you're not being released. All right. Is this next person Mr. Hazlitt or Mr. Walcott? It's Hazlitt? Okay. I think he told somebody he was Walcott. Because I believe the only case that I'm addressing is the 22 MM 708680 providing false ID. And the arrest affidavit says his name is Walcott. Ms. Fleming, do you see what I'm talking about?
Yes, Judge, I thought we were addressing the cocaine and Willis. The 11494. However, I do see his alias as
They're seen already.
You have 2 misdemeanors?
Yes.
Walcott Danny, AKA Hazlitt Ray the third. Okay. Clerk's right, so, in 7086, which is the providing false ID, you had a $500 bond, I'm gonna stay that. The petty theft was a warrant arrest, and that has a $250 bond on it, so I'll stay that. And I'm not addressing the other ones.
I thought it was the possession, is that what you had?
Yeah,
I had the possession and the providing law enforcement as the charges that we were addressing today.
Nope, petty theft and providing law enforcement.
I have cocaine in the Willis. Okay, this is confusing.
Because it looks like it's a 2006.
It is,
On
but
the,
it is a warrant, so the warrant was probably floating around for,
on the arrest affidavit that, I don't know, this is weird.
So he was seen at IA already on the cocaine and Willis?
Yes.
you're asking me, really?
It was a general question.
He
Okay.
was already seen
I have
on
no
that
clue.
case.
Okay.
He also has a hold out of Osceola County. Either he does or Wolcott does, somebody does. I think, the clerk showed me the two affidavit, or the warrant and the affidavit we had, so I've addressed those cases. And since he has a hold from Osceola County, he wouldn't be released anyway, so I'm just gonna, I am appointing the public defender, sir. If there's any confusion about what's going on with the other cases, hopefully they can figure it out, but I don't wanna
She said he already went.
spend all day figuring it out now.
Oh, well, I just need a bond amount, Your Honor, I missed it, go looking at the case.
$250 on the petty theft, $500 on the, was it open container?
Providing
Or no,
ID.
false ID. All right, Mr. Hicks. All right, Mr. Hicks, you were picked up on a warrant, and there's a $1,000 bond on the fleeing and eluding, $500 bond on driving license suspended. I'll leave those. State, I wasn't gonna take any action on the 22 CF 306680. I don't find it sufficiently related, unless you can relate it.
No, Judge.
All right, so I'll take no action on that case. Good luck to you. Mr. Hill? All right, Mr. Hill, you have two cases. In 2019 CF 29580, you're picked up on a failure to appear capious. The judge set that at 0. I'll leave it at 0, as far as the bond goes, I should say. And then 18 CF 1238980, you're picked up for a violation of pretrial release conditions on a warrant that has a 0 bond. I'll leave that at 0. You'll have to seek release from the judges on those cases.
His attorney, Sweet.
When's that, court date?
I don't know. Oh, yeah, it looks like he has private counsel.
Oh, okay.
Leslie Sweet, your lawyer? Yes. Okay. Yeah, you contact her and tell her she needs to file bond motions.
Hines?
If you're current on your bill. that is. Mr. Hines? All right, Mr. Hines.
He does.
Yep, two cases, 22 CT 593380, you have $500 bond, I'll stay that.
And he
In
qualified
22
for
CF
pretrial.
121380, I'm gonna grant you a $1,500 bond on the fleeing and eluding. Oh, wait, he qualifies for PTR. Woo. Hold on, back up.
Thank you, Your Honor.
All right, I'm gonna release you on PTR on both cases. Any conditions? No, I don't think so. Oh, PTR, good luck to you.
Thank you, sir. Thanks. Bless all.
Go ahead, Teresa.
Ms. Jankovic? Okay, Ms. Jankovic, you have a $1,000 bond in case number 22 CF 12143. I'm gonna stay that. Points public defender. If you do post that bond, you'll have no, is Johnny Hunter a co-defendant? I think he's a co-defendant.
Yes.
Yes.
Okay, no contact with Johnny Hunter. Johnson? Oh, this one's a mess. I'm assuming the attempted second-degree murder with firearm came in at 0 because it's PBL, right?
It's actually not, Your Honor. He is entitled to a bond.
What?
It's an F1. The second-degree murder would be, and then the attempt
Oh, it's
knocks it
attempted,
down,
it's attempt.
and the firearm doesn't re-enhance, so it stays at an F1. However, it's not PBL, so he is entitled to a bond.
No kidding. All right. Well, I don't think the bond should be any less than the ag assault with firearm.
No, Your Honor, state would ask that it be, the ag assault with firearm is an F3. The count one is an
It
F1.
came in at 15. That seems high for a 3.
I think it's taking into account his history, Your Honor. He's on probation currently for tampering, false imprisonment, shooting a missile into a building or vehicle,
I see he's
intimidating witnesses.
VOSC,
Yes. So he's,
so that's why they're bumping all these?
yes, Your Honor, because what he is on probation for is semi-similar to this warrant.
Yeah,
of
well,
the shooting into a vehicle.
they're all high except for carrying concealed fire, 150. All right, so in case, oh wait, there's 2 cases. I'm sorry, there's 2 different cases. In 22 CF 12168AO, you have a $4,000 bond on the possession of firearm by a convicted felon and a $150 bond on the carrying concealed firearm. I will stay those bonds at those amounts. In case number 22 CF 11248AO, I will grant you a $15,000 bond on the attempted second-degree murder. I'll stay the ag assault with a firearm at $15,000. Stay the $5,000 on the throwing a deadly missile in the occupied vehicle, and stay the $2,500 bond on the shooting from vehicle. within
Your Honor,
100
just for the record, state would ask for a higher bond on count one, given that it is a first-degree felony and given his history of multiple convictions
What does the
of
state want?
tampering with witnesses and stuff like that.
No, what's the state's recommendation?
The state was gonna ask for 100,000, given that it is an F1. And the allegations within the affidavit.
What does the
and
bond
he has-
schedule say?
There isn't in it, it says to be set.
To be set. Wait, so we throw a dart?
I believe it's just based off his history and the allegations within the affidavit.
He's currently on probation.
Yes.
There's no on-view violation?
Not at this time. He's on the VFOSC hold, so they'll hold him for 5 days. However, Your Honor can find an on view as it is an orange case. In 20
George?
CF 760.
Want to be heard?
Yes, Your Honor, I would object, I believe, the 15,000 as to both counts, you have 15,000 on the second degree and 15,000 on the aggravated assault. In addition, Your Honor, he does have a 5-day hold. I am anticipating a violation of probation soon, and he only has one vote to appear back in 2016. So he does appear for court, so I would just ask that the state bond as that. The only one that's low is the carrot. I don't know which one is low, so 150. All of the other ones are.
Well, that's because it's the secondary offense in that case. There's only 2 counts in that case.
But on the warrant,
Let's see, he's been to DOC. Tampering witness. Times 6. False imprisonment.
State's just concerned he's a danger to the
Intimidate
community,
witness
Your Honor.
2.
As he's on
Felonies,
probation.
3 misdemeanors, 1 failure to appear, and 15. It was a while ago. Is that because he was been in DOC?
Your Honor, state's concern is just, all of his history is violent in nature. And he's on probation for shooting into an occupied dwelling, which is arguably exactly what he did in the
Is
attempted
that
murder
what we call a
case.
drive-by?
I don't believe it would be characterized as that, but yes, Your Honor.
All right. I'll split the difference with you, state and defense. 50,000 on the attempted second-degree murder, 15,000 on the ag assault with firearm, 5,000 on the throw deadly missile, 2,500 on the shooting from vehicle. Appoint the public defender to assist. Good luck to you.
There's no conflict.
Your Honor, state would ask.
Oh, yeah, oh, good, thank you. Yes, also, should you be released, no contact, are there any co-defendants?
State would ask for victims or witnesses. I don't believe there's any code.
All right, no contact whatsoever with any victim, any witnesses. You may not possess any weapons or firearms. If you have any in possession, you must surrender them within 24 hours of your release. Anything else? No? All right,
No,
good
Your
luck to
Honor.
you. Thank you, Ann, I forgot.
Your Honor,
Jones?
we have Nicholas Jones's behavior.
Defense will waive it.
All right, defense waives, appearance, I will, stay as bonds at 1,100. Point PD.
And so that's for no contact, no return,
Oh, is it a,
battery, criminal mischief.
and, all right, if he is released, no contact with victim, no return to the scene. Jordan? Are you Jordan? All right, Jordan, you, in case number 22 CF 12190AO, you have a $3,500 bond, I'll stay that. In case number 22 MM 453AA, you have a $1,000 bond, I'll stay that. If you are released, you're to have no contact whatsoever with any victim, no return to any scene. It's all right?
He asked if he had 2 charges, Your Honor.
That's what I got.
Yes.
1 felony, 1 misdemeanor. Wendy Knight is not with us.
No, Your Honor, she's behavior.
Defense will waive.
All right, defense waives. I'll stay the bonds at 1,000 on count 1, 100, 100 on 2 and 3. Mosley McNeil.
Bonding, Your Honor.
Okay. Palmer. Palmer. Are you Palmer? All right, Palmer in 22 CF 12182AO, you have a $15,000 bond on count 1. $1,500 bond on 2, count 2, 1,000 on count 3, 500 on count 4. I will stay those bonds at those amounts, appoint the public defender to assist you, good luck.
Your Honor, can you advise the defendant he has a hold for immigration?
Oh, sir, even if you post those bonds, you may not be released because you have an immigration hold. Did that Mullen's mom show up downstairs? Did they not let her up, or?
Usually when someone shows up and we're in court, they bring them up. So I would assume she has.
Okay. Rogers,
No, Your Honor, Rogers refused.
waiving or not?
Waive, Your Honor.
Okay, he has a $1,000 bond in 22 CF 1216480. I'm gonna stay that bond. I am gonna revoke his release in 2022 CF 866480. Point the PD to assist him. Good luck. Saint-Amand?
Yes, sir.
Saint-Amand?
Christine St. Thomas.
All right, so this came in on a warrant in case number 22 CF 1095550. The first 4 counts are all ag assault with a firearm, came in at 0. The last 3 counts are child abuse. Those bonds were set at 2,000 in each count. I will leave the $2,000 bonds on the child abuse. I will grant $3,500 bond on each count of the ag assault with a firearm. I'll appoint the public defender to represent Ms. Saint-Amand. If you are released, you'll have no contact whatsoever with any victim, any witness, no return to the scene. Did this involve the residence where she lives?
I do not believe so, Your Honor. I believe it was exchanging of children. and
Okay.
that turned into
All
a
right, so I
situation.
didn't put no separate. Also, you will possess no weapons, no firearms while this case is pending. If you have any in your possession, you must surrender them within 24 hours of your release. Mr. Santiago? Mr. Santiago, in case number 21 CF 12325AO, you were picked up on a failure to appear warrant.
Yes, I turned myself in.
Okay, well, there's no bond, and I'm not gonna grant you one. You're gonna have to seek release from the judge on that case. I am appointing the PD to assist you, however.
So no bond until until a court case.
Well, I'm appointing the public defender, if you had them before or not, but they're your lawyer. They can file a motion to have you released with the judge on that case. But the judge who issued the warrant for you is the one that said no bond, so you're gonna have to go ask that judge for a bond, not me.
Okay. Do you
Okay.
know when my next court case will be or not yet?
No clue. All right, Mr. Sexton?
Yes, sir.
All right, so in case number 22 CF 12181, count one has a $15,000 bond, count two is 4,000, count three is 5,000, count four is 7,500, count five is 5,000, and count six is 2,500. I'm gonna stay those bonds at those amounts, appoint the public defender to assist you. I am going to revoke your release in 2021 CF 2332 AO. You will have to seek release in that case from the judge on that case. Correct. Mr. Vargas?
Sir.
Okay, you've got two cases. The first one, 2022 CF 11932 AO.
There's 4 cases.
Oh, I'm sorry. Oh, yeah. The CTs are sequential. I'm sorry. So you have 4, but I'm dealing with the felony first.
Sir.
Fleming, that is PBL, correct?
Yes, Judge, state would request no bond.
Okay, I'm glad I got one right. All right, sir, on that case, the felony case, the charge is punishable by life, which means you're not entitled to a bond under Florida law, and I'm not granting you one. You have to seek release from the judge on that case. I am appointing the PD to assist you. They can file a motion for you. Now, in 22 CT 4649 AO, 48 AO, and 50 AO, you were picked up on a failure to appear warrant. The judge gave you $100 bonds on each one, and I'll stay those.
Your Honor, on the robbery, state would ask for no contact, no return.
Oh, yeah, thank you. And if you are released in the new case, the robbery case, you're to have no contact whatsoever with any victim, no return to the scene where this occurred. Do we have co-defendants to worry about?
I do not believe so.
And, of course, you are to possess no weapons, no firearms while this case is pending. If you have any in your possession, you have to surrender within 24 hours of your release.
Excuse me, I'm sorry, I'm listening to you.
Okay, I'm not giving you a bond on the robbery charge, but you can ask the judge for release. If the judge does grant you release, it will be in addition to whatever bonds he sets or conditions that judge sets. Shouldn't say he, could be she. You will have no contact with any victim, you will not return to the scene, and you will not possess any weapons or firearms, and if you have any, you gotta get rid of them, surrender them to law enforcement within 24 hours of getting out.
Yes, sir.
Got it? Okay. Mr. Washington? Mr. Washington, in case number 22 CF 4284 AO, you were picked up for failing to appear. The judge gave you a $1,000 bond on count 1, 500 on count 2. And in case 22 CF 5992 AO, you were also picked up for failing to appear, and the judge put a $2,500 bond on that one. I'm gonna leave all of those bonds at those amounts. Mr. Wilks?
How you doing?
Mr. Wilks, in case 22 CF 12188 AO, you have a $3,500 bond. I will leave it at that amount and appoint the public defender to assist you. Good luck to you.
Your Honor, state would ask for no contact, no return. I believe they're roommates.
No contact, if you do get out, sir, if you post that bond, you're to have no contact with any victim. No return to the scene, and what else?
They're roommates, Your Honor, so state would ask for a one-time return.
Oh, is it, oh, he lives there? All right, sir, no contact with any victim, and you must maintain a separate residence. You may, however, return one time with the assistance of law enforcement to retrieve any personal belongings you need.
Is this the number?
All right, this Woldeslassie?
Sir.
Okay. You have a $2,000, in case number 22 CF 12163, you have a $2,000 bond on count one, a $1,000 bond on count two. I will stay those bonds, appoint the public defender to assist you. For some reason, I put a note to myself that I am revoking his release in 2022 CF 11984AO. I must have found that there was a relation. Does anybody want to be heard on that?
He was in pretrial diversion. The only case the state filed on was the carrying, Your Honor, a concealed firearm. I don't see no action taken on anything else. The only thing I would, ask that you consider.
Oh, I remember why. Because the cover sheet on this, it wasn't just carrying a concealed weapon. He also had possession of cannabis in that and a bunch of other stuff. And what you're saying is that the only thing they filed on was the concealed,
So my only, thing is, Your Honor.
but it still involved possession of cannabis and lots of other stuff. I don't have a eidetic memory, so I can't remember exactly what it said.
It does have cannabis. There were two people.
There was a bunch of stuff. There was like a whole paragraph. Oh, here. It was carrying concealed firearm, possession of drug paraphernalia, possession of cannabis.
There were, people.
Oh, wait, I'm sorry. Possession of a firearm and commission of a felony, possession of cannabis with intent to distribute, regular possession, misdemeanor possession of cannabis, possession of cannabis more than 20 grams. Wait, you got them for both? More than and less than?
The officer did.
Oh, must not have gone well.
No, there were two people in the vehicle, Your Honor. They charged both.
Oh, and one said it's theirs, and the other person said it's theirs,
No.
and it was constructive,
Yes, sure. So,
not actual.
so they did not charge my.
Oh, that's a defense attorney's dream.
My only thing is, Your Honor, if you are considering revoking, that you revoke it, and set a new bond as opposed to holding him at no bond. I don't see any other convictions on his record.
So he was in diversion for this?
Yes, Your Honor.
He was in diversion, he got kicked out, and then he got re-sent.
Well, I'm assuming he's getting kicked out now.
Most likely, yes.
He said the only thing he had left was the money that he had to pay, Your Honor.
Well, too bad, because unless, well, I mean, now let's be honest, he could, this case could get no billed, or he could go to trial and beat it, who knows? If all that happens, maybe then he could go back and say, well, let me finish.
There's a note from PTD saying he will not be re-referred again, so once he gets revoked, he's done.
So, Ms. George, is it your position that this other case that had, I don't know, what is that? 37 different charges that they only ended up filing on one is in no way related to the new charge of importation of cannabis, which I read was bringing it in from another state or something. I don't know. I'm just saying, it seems like he's dealing weed.
My argument is that, Your Honor. On the out on bond, the cannabis did not belong to my client, as he was only charged with the gun charge. It belongs to the,
Oh, did the co-defendant, take claim possession?
that I do not know.
No, he did not.
I think I could have answered, that was actually a rhetorical question. What's the state's position? Should I revoke them on this? For some reason, y'all didn't file on any of that stuff, except the firearm. So you must not have been convinced that you had enough,
The
or,
note I have on it is that the car was jointly occupied, so the possession could not be established. So it was mostly a
all
property
right,
possession
all right,
issue.
fine.
State's main concern is that he is traveling
dealing
over
weed?
state lines with,
Or,
Illegal
no,
substances.
he's either dealing weed or he's driving around with a weed dealer. Right?
state's concern is he was flying with weed.
Oh, he's flying. Oh, is this the airport?
This was through the airport.
Wow, people really still try that. Counsel, what case are you here on?
Hey, Judge, good afternoon. I'm here on Christie Saint-Ilmarn.
Oh, we just had,
Started at 1, I'm sorry.
well, technically, yeah, but,
I know how that goes.
we just had her.
Okay, I just wanted to have a chance to speak to her. Did you set a bond on all charges?
Hang on, I don't remember, I gotta go look.
What was it, St. Germain?
Wasn't that-
SAINTILMOND.
Yeah, she wasn't that far back, hang on.
Yes.
Oh, here, I got it. So, I'll tell you what I did. Okay, so it was a warrant,
Right.
and the judge who signed the warrant gave her $2,000 bonds on the 3 child abuse cases, so I stayed those. She had 0 on the 5 ag assault firearm. I gave her $3,500 on each. And also, if she posts those, no contact, no return, no weapons, no firearms.
That sounds fair, Judge. Yeah, all right. I'll speak to my client about it inside, but thank you. Just wanted to let her know that
Yeah.
here that she has a bond on all counts. So we can get her-
Oh, yeah, she does.
All right, sounds good. I appreciate it. Thank you.
Yeah, I think legally she was entitled. All right. Against my better judgment, I will take no action in 2020 CF 11984AO. Is the person from the other case a co-defendant in that other case?
I'm sorry?
Oh, never mind. Okay.
There was a
I
case.
probably should have revoked that, because this guy,
You have to have some faith.
some faith.
He's hanging with the wrong people.
Nah.
He didn't know,
He keeps doing it.
allegedly.
You're not appointing a PD on that case that he just came for, right?
His new one, yeah.
No, I'm talking about the attorney.
Oh, shoot.
Saint,
Ann makes a good point. Did we appoint on St. Emilion? Well, obviously, she's got a lawyer.
yes, Your Honor.
So, I don't know, will you guys just have to file a motion to withdraw, or?
No, I would just ask that you not appoint us.
Yeah, but I think paperwork's done. We're gonna go back?
Yeah, just say you're gonna appoint him.
Okay, not appointing on that one then.
Yeah, because once he files his notice.
All right,
it's not
we're adjourned. We'll cause in each case, subject to any arguments Ms. George would like to make. I am going to appoint the public defender in all cases. And I guess so we have a Portuguese case first. Do we have a witness in the Silva Maia case? Doesn't look like it.
Your Honor, also, the door's locked. Do you mind pressing the button?
Oh, sure.
Thank you.
Is the interpreter on?
Yes.
Yes,
Hello?
Your Honor.
Okay, have you been sworn?
No, sir.
Raise your right hand. You swear or affirm that you will faithfully translate from English to Portuguese, Portuguese to English to the best of your ability?
Yes, Your Honor.
All right, we do not have a witness, so we can use the headphones.
No headphones.
Oh, I'm sorry, this is, never mind. All right, so, Mr. Interpreter, this is, Mr. Silva Maia, case number 2022 MM 7090AO. Mr. Silva Maia, you are here on a domestic violence charge, and you are eligible for release on pretrial release.
Então, senhora Silva Maia. Senhor Silva.
Olá. Oi?
Oi. Então, senhor, você está aqui por causa de uma acusação de violência doméstica, mas o senhor também está marcado para receber uma liberdade condicional antes de ir ao corte.
I'm going to release you on that program. You do not have to post a bond, but you have to follow their rules.
Eu vou soltar você de acordo com esse programa. Não precisa pagar uma fiança, mas tem regras que você tem de seguir.
And one of the rules will be that you must have no contact whatsoever with the victim, and you must maintain a separate residence.
Uma dessas regras é que você não poderá ter contato nenhum com a vítima e que você terá de manter uma residência separada dele.
That means you cannot go home. You must find somewhere else to live. You may return to the residence one time with the assistance of law enforcement to retrieve your personal belongings.
Isso significa que você não poderá voltar para casa. Você terá de achar um outro lugar para morar. Você poderá voltar para sua casa só uma vez, com participação do policial para pegar seus bens.
And I am also appointing the Public Defender's Office to assist you. I would get in touch with your lawyer as soon as possible. Good luck to you.
Eu também vou designar um representante da Oficina de Defensor Público para te ajudar. Eles vão entrar em contato contigo. Boa sorte. Thank you.
Thank you. Thank you, Mr. Interpreter.
You're welcome, Your Honor.
Do we have, out in the gallery, do we have Mrs. Gasson?
Yes, Your Honor.
Okay, I'm assuming this is Mullen? Okay, can we bring up Gasson? Is Gasson back there? I mean, I'll do him, and then can we do Gasson next?
Yes, sir. Yes, sir.
I appreciate it.
Yes, sir.
This isn't Spanish, is it? Okay, just checking. Yeah, I know. Well, I don't know, where'd you have Gasson? Is it up here?
It's like 5 cases down.
Okay. All right, you know what, we'll just do them in order, it's fine. He's 5 cases in, it's fine. All right, Mr. Mullen, you're here on a domestic violence charge. I know there was some indication, Ms. Keys, okay, I forgot your name for a minute. You know, there was some allegations of mental health. Could he be screened for mental health release?
Yes, he can.
Okay. So, sir, I'm going to grant you a bond of $500 that you can post and be released. If you do post that bond, you will have no contact whatsoever. I believe it was your mother. No contact with the victim. You must maintain a separate residence. You may return one time to retrieve any personal belongings you need. I will also order that you can be released under the mental health Release program, if you qualify. So you either post the bond or you be screened and qualify for mental health, you can be released. But in any event, you may not return to the residence. You must find somewhere else to live. You can, as I said, you can return with law enforcement, retrieve your stuff, but you can't live there, all right? And the public defender is appointed to assist you. Good luck to you. Mr. Rose, I think your case is in some of the first ones here, so.
Thank you.
Okay, Mullen's good to go.
I have no money. Sir,
So you get to go,
I don't.
please go that way. Yes, sir. Yeah, Steve. All right, Ms. Popelka?
Yes, Your Honor, Pope.
You are here on an out-of-county warrant that has zero bond. I'm going to leave it at that. You'll have to seek release from the judge on that case. All right, good luck to you. All right, Mr. Burnett? Mr. Burnett? Okay, Mr. Burnett, I believe what I'm addressing today is 2020 CF 7131AO, which is a violation of probation. I'm not granting you a bond on the VOP. You will have to seek release from the judge on that case. All right, good luck to you. Oh, this is Scholl. Ms. Keys, what does it mean to have a high-risk sex offender hold?
He just, I hope the detainer is cleared once he goes before the initial appearance judge.
All right, are you Scholl?
Yes, sir.
All right, you are here for violation of probation, and you're not entitled to a bond on a VOP. I'm not gonna grant you one. You will have to seek release from the judge on your case. Okay? Good luck to you. Is Mr. Rose here on black? Mr. Rose, I believe, you're here on Nathan Black? All right, that is the next, that's all right. Okay, can you, just for the record, announce your presence?
Yes, Your Honor, Joseph Flynn on behalf of Nathan Black, who,
Your Honor, my apologies. Are you gonna address Black's case now?
That's the one that came up on my list.
should be with you.
Gasson's, I have Gasson after this.
Black is right here.
All right, do we have any witnesses for Black?
I didn't see her out there, Your Honor.
Yeah, well,
Yeah.
all right, so my intention was to, you came in on $1,000 on the robbery, $1,000 on the criminal mischief, 500 on the resisting, and obviously he doesn't come in with any bond on the battery. My intent was to grant him a $500 bond, order no contact, separate residence. I don't believe he needs to return based on the affidavit.
No, Your Honor.
Okay, so,
Bonds are zero, so you're setting the bonds?
thought it came in, oh,
Yeah, they all came in, no bond, Your Honor.
oh, they did? Oh, well, then that's my notes. Then I guess that's what I was gonna say. All right, so, yeah, my intent was to give him 500 on the DV battery, 1,000 on the robbery, 1,000 on the mischief.
Your Honor, state would ask for higher on the battery. He's currently on probation for a battery and has
Same victim?
1, 2, 3, at least 3 prior batteries. So state believes that it,
Your Honor, I would state that most of those battery charges were dismissed before
Well, is
this.
that because the victim wouldn't cooperate?
Not in every circumstance, but at least one, yes.
The same victim, Ms. Fleming?
the one that he's currently on probation for.
Was he currently under a no contact order with the alleged victim in this case?
No,
The one he's currently on probation for is not the same victim. It was a girlfriend at the time in
Okay.
2021.
All right. Well, I appreciate the state's position, and I think it's certainly reasonable that you consider his history. But I think, unless you wish to argue otherwise, I'm going to leave him at 500, 1,000, 1,500.
no, I think it's appropriate, Your Honor.
All right, and sir, if you do post those bonds, you will have no contact whatsoever with the alleged victim in this case. You obviously have to live somewhere else. I don't believe that's an issue because you don't live together anyway.
Correct, sir.
I don't recall, was there any reason for no weapons, no firearms, Ms. Fleming?
Not within the affidavit, no, Your Honor.
Okay, so, all right,
All right, thank you, Your Honor. That's all I have before the court.
yep. I think I called him by the wrong name. That's not Rose. It's not Mr. Rose, I forget his name. Sorry, dude. All right, Mr. Gasson. I think I'm saying that wrong. All right, ma'am, can you raise your right hand? You swear or affirm everything you say today should be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Sorry?
Yes, Your Honor.
Okay, you can put your hand down. All right, could you state your name for the record, please?
Nikki Gasson.
All right, and Ms. Gasson, you are the wife of Adam?
I am.
Okay. So, the reason I asked this to be reset is because I understand that you and your family intend to return to England on Tuesday, I think.
Yes.
And this came in with bonds. I don't know if you have a similar system in the UK.
No.
But here, when you are charged with alleged to have committed a crime, we use a bond schedule that the whole purpose is to ensure that somebody will show up for court.
Yep.
The penalty being that if they fail to appear, then they forfeit the money. And you can either post the money yourself in full, or you can get a bondsman at 10% of what your bail is set for. Unfortunately, in your husband's case, because he's not a U.S. citizen and he's already announced his intention to return to England, a bondsman would not provide the bond, or the insurance, I guess. And so he would have to post the entire amount, and the bonds that came in were $5,000 on count one and $1,000 on count two, partially because he's a flight risk. Now, yesterday, he appeared, and typically, this type of thing is not handled here. I did appoint the public defender's office to assist him. He has an attorney. And normally what would have to happen is they'd have to file a motion, get a hearing in front of the judge. We talked about they could do that on an emergency basis, but I was concerned that it wouldn't happen quick enough. So I asked that this case be rolled to today. Your husband seemed to indicate to Ms. George yesterday, who's acting as his attorney at this point, that he couldn't afford to post a $5,000 bond or a $1,000 bond. So I asked you to be here, you're under oath. Is it your position that your husband cannot afford to put up $6,000 to be released?
He can't, and neither can I.
Okay. Approximately how much a month is his take-home income?
Depending on how many shifts he works in a week, anything up to about 2,000. But it depends on whether he works 4 days, 5 days. It depends on how much work's there at the time.
Okay. So 2,000 a month roughly, and that's pounds?
It is English, yes.
Okay. Which up until recently would have been worth more than $1.
Yeah. Now, that probably would work out to be about $2,000 and about $50, something silly.
And you have how many kids?
3, well, 5. He's got 2 from previous relationship and a 3 with me.
Does he provide support for the other?
No, they are grown. They are.
Oh, okay. So what, in your opinion, could you afford to post if you were required to post a bond?
At this present moment in time,
Yeah.
I could possibly scrape together about 1,000.
State, you want to be heard on this? And just for the record, your co-counsel, Ms. Eugene, indicated yesterday that she was, I should tell you, Ms. Gasson, somebody who is from out of the country, typically, to be released, they have to surrender their passport. And the reason is so that they can't leave until their case has been resolved, or they've gotten permission from the judge on the case to go somewhere. The state attorney yesterday was empathetic and indicated that the state would not be asking that the passport be returned. So bottom line is here, I'm doing all this because I want to release him. I want him to be able to go home. My concern is if you guys go home tomorrow and the judge on the case at a later date says he needs to be in court, well, he needs to be in court. Now, the reality is, and this is, well, it's Judge Gibson's now, but she's going to civil, so I don't know who's taking over that division. The judge could allow him to appear virtually. He has an attorney here. The attorney could appear for him in many of the court hearings, and he wouldn't be required to be here. And so he could potentially resolve this case and not have to come back. But that's not up to me. That's up to the judge on the case. And so, but I don't want him sitting in here, and I don't want him, stuck and not being able to return to home. So what's my guarantee that if he has to be here in court, I don't know if he will, but it's not, again, it's not up to me. So if he has to be here in court, he has to be here in court. Can you get him back here, or can he get himself back here if the judge tells him, hey, man, you got to be in court?
Yes, he can.
Even if he says, Judge, I'm in England. I can't just pop in the car and come over there. I don't care. You have to book a flight, et cetera, et cetera.
If he has to be here, he'll be here.
All right. Can I get Miss Eugene and Miss George up here for a second? All right, Mr. Gassens, I'm going to grant you bonds in the amount of 500 in case number 2022 CF 12122680, $500. $100 in case number 2022 MM 705480. I am not going to require that you surrender your passport. That means when you are scheduled to return home, you can return home. I need you to understand, though, you know, it's possible, I don't know, but it's possible that you're thinking, hey, man, I just got drunk and I pushed the guy and I'm sorry, it was a bad night, you know? And no big deal. But, you know, you've been charged with a felony, which I don't know if you have felonies and misdemeanors over there. I guess you do. It's not a small deal. And I need you to understand that I want you to take it seriously. Clearly, you've been held for, I guess, 2 nights now. And frankly, to be honest with you, if I hadn't held you over and asked for your wife to appear today, you probably wouldn't be getting out. It might even be tough to get you out by Tuesday, and you'd probably be missing your flight. So, you know, but given your situation, the charge is, I don't know, would you call that moral turpitude? I don't know. Look, I don't want you to, I want you to get out, I want you to go back with your family, but I don't want you to just ignore this. You need to stay in touch with your lawyer, either telephonically or WhatsApp or whatever. And if the judge tells you you got to be in court, guess what? You got to get on a plane. That might not happen. You may be able to address this and resolve this case without having to return here. I don't know. But I just don't want there to be any confusion about the fact that if the judge on your case wants you here, you got to be here. And that's not up to me. Okay? So, stay in touch with your attorney. I would, at the very least, this is Gibson's division, so whoever is in that division, I would, before you leave the country, I would make sure you at least get on the phone and talk to your lawyer. You know, hopefully you can salvage what's left of your vacation. I mean, I get it. It's kind of crummy. But, okay, so just, don't ignore this. Stay in touch. You know, if you go back to England and nobody ever hears from you again, guess what? There's going to be a warrant out for your arrest, and you can never come back here without going to jail. And maybe you don't want to come back here after this. I don't know. But I'm trying to make an impression on you that I need you to take it seriously, follow through on everything. I really don't think that, you know, I think you can resolve this case without, you know, a much ado. But if you ignore it and we never hear from you again, it'll get worse. Okay? All right. I appreciate you coming today. I guess you could go down to the first floor and find out who to give the money to. And if you can do that this morning, he'll be out in probably 3 or 4 hours.
Thank you, Your Honor.
Okay?
Thank you.
All right. He may be more afraid of what his wife's going to say to him than what the judge in the case is going to say to him. All right, Mr. Brown?
Yes, sir.
All right, Mr. Brown. In case number 22 CF 10622, count one is punishable by life. Am I correct?
Yes.
I got to check with you guys now.
Yes, Judge, count one is an F1 that is punishable by life at this time.
Oh, wait, this came in on a warrant.
Yes.
All right, so I don't even have to think about it because it's already on it. All right, so you have no bond on count one because it's punishable by life. You're not entitled to a bond. On count two, I'm granting you a bond of $500. However, if you do get released, if you seek release from the judge on the case and you're released and you post the $500 bond on count two, you will have no contact whatsoever with the victim. You will maintain a separate residence. I didn't see if there was any. Oh, they didn't reside together, so that's fine. So that shouldn't be an issue. Can't maintain a separate residence, no contact. No weapons, no firearms, or it was just an assault or battery? Was it just?
He followed her into her apartment.
Okay, all right.
So
So
same
that's
as
it.
for-
No contact, separate residence, $500 bond, but no bond on count one.
Your Honor, State would ask for a no return to her
Oh,
apartment
and no return, sorry.
and no weapons.
Well, that's what I was asking. So there was weapons?
There wasn't, however, given the degree of felony, State would ask for no weapons at this time.
All right. And, sir, if you get out, or when you get out, you will possess no weapons, no firearms while this case is pending. Okay. Good luck to you. Daley?
Sir?
I know we have some people out there, so somebody let me know if we have a witness in any of these cases. Okay, in 22 MM 7083 AO, I'm going to grant you a $500 bond. If you post that bond, you'll have no contact whatsoever with the alleged victim. I'm going to also state separate residence. It's not an issue because I don't believe you live together anyway. But if you were thinking about it, you can't do it now. And in case number 22 CF 12170 AO, you have a $1,000 bond. I will leave it at $1,000. All right? Good luck to you. Gowans? All right. I was just curious why this one didn't come in as DV, but whatever. Sir, I'm going to grant you a $2,500 bond in 22 CF 12152 AO. If you post that bond, you will have no contact whatsoever with the victim. You will maintain a separate residence. You may return one time with under the escort of law enforcement to retrieve your personal belongings. Good luck to you.
Appreciate it.
Oh, you know what? I think this next case is the one I was thinking of. That came in with, it was 0 on count 1, 0 on count 4, and then it had 1,500, yeah. Mr. Grant? Okay, I don't see anybody coming up. All right. In 22 CF 12100 AO, I will grant you a bond of $3,500 on count 1. You have a bond of $1,000 on count 2, $500 on count 3. I will stay those, and I'll grant you a bond of $500 on count 4. If you post these bonds, you are to have no contact whatsoever with the victim. You must maintain a separate residence. You may return one time to retrieve your personal belongings, and while this case is pending, you will possess no weapons, no firearms. Good luck to you.
It says no return on the warrant.
Sorry?
It says no return on the warrant.
Oh,
I believe there's a no return to the sports bar, Front Row Sports Bar and Grill.
oh, okay. Oh. Somebody tell them you can't go back to the sports bar. All right, no return to the scene. Hill? Okay. 22 CF 1219280. I will grant you a $2,500 bond on count 1. You have a $1,000 on bond on count 2. I will leave it at that amount, and I'll grant you a $500 bond on count 3. That's not a separate case, is it? Count 3?
No, Your Honor.
Okay.
Same case.
Now, if you post those bonds, you'll have no contact whatsoever with the victim. You maintain a separate residence. I know, I understood, I believe that you live elsewhere, but you sometimes stay, it said, so you can't do that. I was gonna order that he could return one time, because it says you may keep stuff there. Do you need to go back?
Yeah, I do.
All right, you may return one time with the assistance of law enforcement to retrieve your personal belongings. Now, I am gonna revoke your bond on 22 MM 6547 AO. So you have to seek release from the judge on that case. And I am pointing the PD, so you can speak to them about helping you with that.
Yes.
Mr. Perez?
Sir?
Okay, we have a witness. Ma'am, can you raise your right hand? Do you swear or affirm everything you say today should be the truth, whole truth, nothing but the truth?
Yes.
All right, put your hand down. Could you state your name for the record?
Gabriela Budasov.
What was the last name?
Budasov.
Budasel?
Budasov. Budasov.
Okay. All right, and what's your relationship to Mr. Perez?
He's my boyfriend.
All right. And you're the victim in this case?
Yes.
Are you here today to tell me, well, you don't live together, correct?
We do at the moment, yes.
I'm sorry?
We do at the moment. We do at the moment.
Oh, I didn't think you did. All right, well, so two things. Are you here to tell me that you want to have contact with Mr. Perez, or you do not?
I do want to have contact.
You do?
Yes.
So does that mean you want him to come back to the house?
Yes, he can.
You're not in fear of this person?
No.
I mean, the charge is aggravated battery.
It was a misunderstanding.
Yeah, I know that people like to say that, but it's not always a misunderstanding. All right, well, if I do allow him to return, it would be under a non-hostile contact order. And just so we're clear, that means if he acted aggressively or violently or even looked at you cross-eyed towards you, and you pick up the phone and you call law enforcement, he will be hauled back to jail, and nobody's gonna ask his side of the story because he's under the jurisdiction of the court. He doesn't get that luxury. He just comes straight back. And are you here today to tell me under oath that you will make that phone call if he steps out of line?
Yes, sir.
No questions asked.
No questions.
All right. Well, Mr. Perez, I'm going to grant you a bond of $3,500 on count 1 and $1,000 on count 2. I will, if you post those bonds, you will be able to return to the residence under a non-hostile contact order. That means no hostility at all. Not verbally, not physically. As I said, don't even look at her cross-eyed.
Yes, sir.
Because if she picks up the phone, you're coming back here, and you're gonna wanna say, no, it's missing, no. They don't care. You're coming to jail. Clear?
Yes, sir.
Do we need no weapons, no firearms, Ms. Fleming?
Your Honor, state would ask for it, given his history.
Okay. While you're out on release on this case and it's pending, you will possess no weapons, no firearms. If you have any, you must surrender them within 24 hours of your release.
Yes, sir.
All right, thank you for coming. Good luck.
Your Honor, Edith Robert is currently on mental health status.
are we waiving?
Yes, Your Honor.
3,500 on, in 2022 CF 1066880, 3,500 account 1, 500 on account 2. No contacts, separate residence. My note was returned with a question mark. I don't, do we know if they reside together?
This has no alternate address provided, so I would ask for a one-time.
Okay, one-time return with law enforcement. And I'm not going to take any action on 21 CF 7622. I don't find them sufficiently related. Okay, is this Mr. Rodriguez Zotero?
Yes, sir.
Okay. In 22 CF 1219480, I'm going to grant you a bond.
Your Honor, just for the record, state would like to put on record that he does have a prior battery on a person 65 or older, same victim, at least 6 times, a prior simple assault, same victim, some prior abuse of an elderly adult, same victim, and prior bat DV, also same victim.
Is this the 73-year-old mother who drove away to call the cops?
Yes, I believe so.
And Your Honor, none of those statement board.
Want to put money on why?
Your Honor, can Gander ask to why?
Is there mental health, or is this just,
Not to my knowledge, Your Honor.
Mr. Rodriguez Zotero, what is the deal with you and your mother?
Sir, I think.
You keep getting picked up for allegedly battering your mother. Right?
Yes, sir.
You think it's okay?
Sure not.
Well, your actions would indicate otherwise. I heard 6 times. And how many times never got reported? So, Ms. Fleming, you're asking for a higher bond than 3,500?
Yes, Judge. He has one from January 27th, ag battle with a deadly weapon DV, battery on a person 65 or older, bat DV,
Same victim?
same victim. He has another one 9 days earlier, early in January 2021, bat person 65 or older, bat DV. He has one 2 months prior to that, November of 2020, bat 65 or older, bat DV. He has one a month prior to that one, bat person 65 or older, bat DV. Another month prior to that one, bat domestic violence, abuse of an elderly disabled adult, bat 65 or older.
Ms. Fleming, are you arguing that there's no condition of release that would protect the public being his elderly mother?
Aaron, I'm not making that argument at this time, as he is otherwise entitled to bond. So state's not gonna make that argument at this time, and I also have not filed a pretrial detention motion. However,
Are you trying to kill her?
Your Honor, may we approach on this case, please?
Sure. All right. Mr. Rodriguez Zotero. I'm gonna split the baby, Ms. Fleming. I'm gonna grant you a bond of $2,500 in this case. However, one of the conditions of your release is that you are equipped with a scram monitor. Do you know what that is? Let me tell you what that is. A scram monitor is a device that is attached to your leg. If you drink alcohol, it detects it because the ethyl seeps out of your pores or something. I don't know how it works. But if you drink any alcohol, it alerts the monitoring service, and they alert law enforcement, and they come and arrest you because it's a violation of your pretrial release. So I will grant you the bond of $2,500. on the condition that you are fitted for and equipped with a SCRAM monitor device prior to your release. If you are released, you must have no contact whatsoever with your mother. You must maintain a separate residence. You may return one time with law enforcement escort to retrieve your personal belongings. You will consume no alcohol, no drugs, obviously. And just so you understand, you have one beer. That thing goes off, cops are going, and it's a GPS too, by the way, so they know where you are. Cops are going to come to where you are, throw you in the car, and bring you back here if you drink. Okay?
I understand, sir.
All right. Public defender's appointed to assist you. Good luck to you. All right, Anderson,
Yes, sir.
we have a witness, sir. Can you raise your right hand? Do you swear or affirm everything you say today should be the truth, the whole truth, nothing but the truth?
Yes, sir.
Can you put your hand down? Can you state your name for the record, sir?
Resident Jamar Skinner.
What was the last name?
Skinner, Resident Jamar Skinner.
Skinner?
Yeah, Skinner.
Oh, we have another witness. Can you raise your right hand? You
I'm not a witness.
She's not a witness.
I'm just speaking on behalf of my sister, but he's speaking.
Well, if you want to speak on the record, I got to swear you in. You swear or affirm everything you say today should be truth, whole truth, nothing but the truth?
Yes.
All right. All right, Mr. Skinner, what's your relationship to Ms. Anderson?
She's my fiance.
Okay, do you live together?
Yes, sir.
Are you here today to tell me you want to have contact or not?
Yes, sir. I want to have contact.
You live together?
Yes, sir.
You want her to come home?
Yes, sir.
You're not in fear of her?
No, sir.
All right. If I do allow her home, it would be under a no hostile contact order, and so if she were to act out in any way and you call law enforcement, she'll be hauled back to jail, no questions asked. Are you here today to tell me under oath that you'll make that phone call if it's necessary?
Yes, sir.
All right, you shrug your shoulders like, yeah, of course.
No, my back is hurting me.
Oh, okay. All right, and what, sister, what's your last name?
Anderson?
Okay, and were you a witness to this event?
No.
No.
Okay, so what are you here to tell me?
I just wanted to let you know that she is good to come home. She's okay.
Okay, I appreciate that. You don't live with them, do you?
No.
Okay. All right. Ms. Anderson, I'm going to grant you a $500 bond. If you post that bond, you may return to the residence. However, you'll be under a non-hostile contact order. You can't act aggressively or violently in any way whatsoever. Mr. Skinner picks up the phone, calls law enforcement, you will be arrested and brought back to jail, and no one's going to ask your side. You understand?
Yes, sir.
Also, while this case is pending, you will possess no weapons and no firearms. If you have any, you must surrender them within 24 hours of your release. Understood?
Yes, sir.
All right, and finally, I am appointing the public defender to assist you. Good luck to you, thank you.
Hey, seriously.
No.
Your Honor, I'm sorry. Robert Burns is currently on mental health.
Waiving?
Yes,
All right. PD waives Burns' appearance, $500 bond, no contact, separate residence, may return one time with law enforcement. Combs? Witnesses for Combs, I don't see any.
Your Honor, my apologies. Is that your victim? Is he the victim?
Yes.
Her victim is also Mr. Molen. He's,
Oh, yeah, I know. So, oh, you want to bring them both
so
out?
it's up to you, Your Honor. Do you want to?
Normally, Your Honor, I would to see if they would like contact with each other, actually.
You want Molen?
Let me just. Yes, Your Honor, could we have both?
Okay.
brought in?
You know, last time I was here, we had the boyfriend, girlfriend, who had a horrible history of beating the snot out of each other. And they sat here and told me how much they loved each other and didn't want to be separated. All right, so you're Ms. Combs. You are Mr. Moylan?
Yes, sir.
All right, and you guys are both here because there was an incident at your residence, correct?
Yes, sir.
Yes? Okay. Hang on, I gotta get Moylan's sheet. Oh, here it is. Look at that, turned right to it. All right. So, Ms. Keys, Combs qualified, Moylan did not. Why didn't he? Oh, because he's not a good candidate. Okay. All right. Here's the deal. Ms. Combs, you want to have contact with this guy? You're not in fear of him? If he, and so you want him to come home? Mr. Moylan, you want to have contact with Ms. Combs?
Absolutely, sir.
You're not in fear of her?
Not at all.
And you want her to be in the home?
If I may add,
I probably wouldn't. All right, well,
there was no physical contact. I can speak for myself now.
okay. Ms. Combs, you qualify for release on pretrial release. You don't have to post a bond. You have to follow their rules, okay? So I'm going to release you under that program. You may return to the residence. You may have non-hostile contact with Mr. Moylan. If you act aggressively in any way and he calls the cops, you'll be arrested, brought back here, no questions asked, because you're under the jurisdiction of the court, so you don't get that luxury. Mr. Moylan, I'll grant you a $500 bond on yours. If you post that, you may return to the residence. You are also under a non-hostile contact order.
Yes, sir.
And if Ms. Combs calls the cops and says you acted aggressively in any way whatsoever, you will be brought back here, no questions asked. Understood?
Yes, sir. If neither of us decide to presume with press.
That's not a question for today.
Okay.
All we're doing is deciding if you're getting out. All right? Now, the public defender has been appointed in both your cases. You can talk to your lawyer, although they're going to have to conflict off one of them. He's good. Oh. All right, Mr. Hannah?
Yes, Your Honor.
Is it Hannah or Hannah?
Hannah.
Hannah. Mr. Hannah says his lawyer told him it was okay. Ms. Fleming. Lawyer says fine. And apparently when he was released, he went straight home. Now, the victim went elsewhere. Sir, you were released on a domestic violence battery charge, and it appears you were ordered to live somewhere else, but you didn't care. You said, nah, I'm gonna go back to my house. You went right back to your house. You've been living there ever since, and your, I don't know, wife, girlfriend, whoever the victim is, they left. And I know that you were told before you left here, that you had to live somewhere else. They may have given you permission to return one time with law enforcement to retrieve your belongings, but you were not allowed to go back. And when you got arrested, you told the cop, well, my lawyer said it was fine. Is that essentially what we're looking at here? So were you confused when you left here the first time?
Yes, I was confused.
You were confused.
I was confused.
All right, let me clear it up for you. Okay? I'm going to give you a $1,500 bond in case number 22MM454AA. You can't go home. You go somewhere else. I suppose he can return one time with law enforcement to retrieve his belongings since he never left. But you are to have no contact at all. You live somewhere else. You do not go home. And you do have the public defender appointed to assist you. Good luck to you.
Your Honor, he does have that out on bond case.
Huh?
He does have an out on bond.
I know, it's the.
It's tied to
It's
the-
the underlying one, and
You can't go home except for
I'm not gonna
personal to gather any belongings.
revoke it on that because says he was confused.
Then you go. Do you have to go with law?
He should no longer be confused.
That's it. And then you can't go back anymore.
I get it, Ms. Fleming, I understand it.
Well, he also was supposed to have no contact and he was emailing her, and so he violated in other ways as well, Your Honor.
Yeah, let's make sure you understand that too. Not only can you not live there, I've said numerous times, you can't even contact, you can't email your wife. You can't leave her text message or call her, or even have a buddy do it. No contact. None. Got it? Because what the state is referring to is what they would like me to do is revoke your bond on the domestic violence charge that you initially showed up here. Okay? Which I'm not inclined to do because essentially that's what you got arrested for, was violating the conditions of release on that. But I could revoke your bond and you couldn't get out anyway. You'd have to seek release from the judge on the case. But you said you're confused. Are you confused anymore?
No, I'm.
Excellent.
But I have
Good
a
luck.
question.
No, good luck.
Call the attorney in.
McKay. Sir, raise your right hand. Do you swear or affirm everything you say today should be the truth, whole truth, nothing but the truth?
Yes, sir.
All right, can you state your name for the record?
Jason Rodriguez.
Mr. Rodriguez, what's your relationship to Ms. McKay?
That's the mother of my child, and she's living in my house right now.
Okay, so but you're not in a relationship? She just,
We've known each other for 5 years, so I guess, we're
are you
bonded.
dating or not?
Dating. We're not dating.
You're not dating. You live together, you have a child together, you see other people.
No, we're not seeing anybody else right now, but she should be getting her way into her own apartment here soon, and I'm helping facilitate that.
All right, so are you here today to say you want contact or not?
Yes, I like a peaceful contact, or I think you would call it the
So you want her to return to the house?
I'm sorry?
You want her to return to, be able to return to the home?
Yes, sir.
Your Honor, one question?
If
Yeah.
possible, I would like to
Hold on.
Sorry, sir.
Ms. Fleming, you would like to inquire?
Has anything like this ever happened before?
Yes.
Approximately how long ago was the last time?
A year ago.
That's all, Your Honor.
May I speak?
All right, I'll grant her a $500 bond. If you post that bond, you may have non-hostile contact with Mr. Rodriguez. Is this the hair puller? Okay, can't pull his hair, you can't yell at him, you can't be violent or aggressive in any way. Sir, if that happens, and you pick up the phone, by the way, you're gonna tell me today you'll make that phone call, right?
100%. I need to protect myself.
And you understand that if you do that, she's gonna be brought back to jail with no questions asked.
Yes, sir.
All right. All right, $500 bond, no hostile contact, you have the public defender, good luck to you.
Thank you, Your Honor.
Can I make a statement, sir?
I wouldn't.
Pardon.
Ms. Martello? Do I sound angry today? Am I coming off as angry? Oh, no. Okay. I feel like I'm coming off as angry.
No.
Ms. Martello? Yes. All right, I think that's it for witnesses, right, guys? Okay, Ms. Martello, I'm gonna grant you a $500 bond. If you do post that bond, you will have no contact whatsoever with the alleged victim. You must maintain a separate residence. You may return one time to retrieve personal belongings if you need to.
Okay, thank you.
Good luck to you.
Can I?
Keep your
can I
mask
ask
up.
For something?
I would ask Ms. George, because I am appointing the public defender to represent you, so she is your attorney, and it's better if you direct inquiries there. Mr. Rodriguez Lopez? Sir, in this case, I'm gonna grant you a $500 bond. If you post that bond, you'll have no contact whatsoever with the victim. You must maintain a separate residence. You may return one time with law enforcement to retrieve your personal belongings. And I've appointed the public defender to assist you. Good luck. Mr. Torres? Sir, I'm gonna grant you a $500 bond. If you post that bond, you'll have no contact with the alleged victim. You must maintain a separate residence. My understanding is that you don't live together, correct? All right, so there's no reason for you to go back. No contact, live somewhere else, $500 bond, and you have the public defender to assist you. Oh, Ms. Britton?
Yes, sir.
All right, Ms. Britton, you're here on a warrant out of Lake County. It has 0 bond. I'm gonna stay that. You'll have to seek release from the judge on your case.
Can I ask you something? The person that was supposed to be filing charges, they said they didn't want to. And I was trying to see if I can get a button and I'll pay.
You have, ma'am, this is something you have to take up with the judge in Lake County.
Do you know when they would be coming to try to transfer me then to Lake?
No idea. All I know is the judge said they're not granting you a bond.
Until I see him?
Sorry?
I'm sorry, I'm losing my voice.
You have a lawyer in the Lake County case?
No, sir, I don't know, like, nobody talked to me or anything.
Do I point you guys in?
So we don't do anything on that out of county, Your Honor. They just get transported back.
Yeah, unfortunately, I think you're just gonna have to wait till Lake County comes and gets you, and then they can give you more information. All we have is the warrant, whether you have a bond or not, which you don't, and I basically just tell you what the bond says, or what the warrant says, and the warrant says no bond. So you gotta wait till they pick you up.
Your Honor, it's my understanding it's usually within 72 hours.
Well, there
Like,
you
we'll
go.
come get her.
Okay? All right,
Jones Roderick, his behavior. Come on.
all right, do you waive for these or no?
Yes, Your Honor.
All right, so, I believe I'm only addressing the out-of-county warrant from Hillsborough. It has a $500 bond. I'll stay it at 500. Ms. Lewis? All right, Ms. Lewis, you were picked up on a warrant out of Hillsborough County. There is no bond on that warrant. You will have to seek release from the judge in that case. Okay?
I'm sorry, I couldn't hear you. She was talking.
You were picked up on a warrant out of Hillsborough County that has 0 bond on it, meaning if you want to get a bond or get released in any way, you'll have to file a motion with the judge on your case in Hillsborough County. There's no bond, and I'm not granting one. I'm not changing that.
Do you know why I'm here? Why they arrested me?
Because you had a warrant.
For what?
I don't know.
Don't know. That's what I'm trying to find out.
Well, they'll come get you. You might give you more information when you get over to Hillsborough. Mr. Aiden or Dan?
Aiden, sir.
Mr. Aiden, you're here on a violation of probation. The judge listed a bond of $7,500 and also noted that that is not to be modified. So you could post a bond of $7,500 and be released on this, or you can ask your attorney. Now, he's Orange County, right? So I am appointing?
Yes, Your Honor.
All right, appointing the public defender. You can ask your attorney to file a motion to modify if you'd like, or you can post that bond. Good luck to you. Mr. Armstrong?
Yes.
All right, you're here on 2 different cases, 21 CF 15905 and 22 CF 936 AO. They're both AO. They're both violations of probation. You have no bond on that. It will stay at no bond. You'll have to seek release from the judges on those cases. Mr. Azevedo? Sir, you're here on it for violation of community control. There is no bond on that. It will stay at no bond. You'll have to seek release from the judge on your case. Good luck to you. Ms. Dow?
Zara Dow, yes, sir.
Dow, or Ms. Dow, you're here on a violation of probation. There's no bond on that. You'll have to seek a bond from the judge on your case. Good luck to you. I forget, this is Mr. Leon?
Sir.
Am I addressing both?
I believe so,
Yes.
Judge.
Okay. One's out of county, one, I guess the 21 CF 1871 AO is Orange County. So if you have a violation, you're being violated for probation. I believe one in Orange County and one is St. John's, maybe.
Yes, sir.
Yes.
So, there's no bonds on that. You're not entitled to a bond. You'll have to file a motion with the judge in those cases to get released.
All right, can you please repeat that?
You'll have to file a motion with the judge on those cases to get released.
So,
So you're not going anywhere until the judge says you can go. Okay?
yes, sir.
Okay.
Donna, Tony Webb refused.
All right, in 21 CF 7550AO, it's a violation of probation. I'm not granting a bond. You have to seek release from the judge. This is, so this is Mr. Travato?
Yes, Your Honor.
Okay. All right, in case number 2021 CT 7393AO, violated your probation. I believe that was DUI probation, so I'm not granting you a bond on that. You'll have to seek release from the judge on that case. Am I addressing 22 CT 5435?
For the add-on bond, yes.
Okay, well, no, but it's listed, well, it's
That one's
listed as a
endorsed bond.
detainer. It's also listed,
One is in the charges as an endorsed bond, then he has the add-on bond. So you're addressing just the add-on bond.
okay, well, it's listed twice here for some reason.
Your Honor, state would ask, request no action. We don't know when the violation occurred.
Okay.
Your Honor?
Yeah, I'm gonna take no action on 2022 CT 543580. All right, Ms. Fleming, when you are ready to go on 33 days.
I am ready when you are, Judge.
All right, first one is Carnley 22 CF 10472AO.
I don't know how long it's gonna take, so I said call and speak to the attorney. They did give me a better idea.
10472 denied and information was filed.
Reed 2022 CF 10683AO.
Granted, notice non-filing.
Hawkins. Oh, I did, okay. Hawkins, 22 CF 10855.
Granted, notice of non-filing.
Delion, 22 MM 6352.
Granted, notice of non-filing.
Scott, 22 CF 10807.
Granted, notice of non-filing.
Walker, 22 CF 10824.
Granted, notice of non-filing.
Bird, 22 CF 9152.
Granted, it was no build.
Phillips, 22 MM 6331.
denied and information was filed.
Thomas, 22 CF 10826.
Granted, notice of non-filing.
Hearns, 22 CF 10149.
Granted, it was no billed.
St. Pierre, 22 CF 8928.
Granted, it was no billed.
And Herrera, 22 CF 10870.
Your Honor, this one is slightly premature. The
Oh, is
33rd
this the one that we got an email on? Yeah.
The
So
33rd.
it's 30 days is run, but the 33 hasn't.
Yes. So state would just ask that you grant it and put the language, the defendant's not to be released until the 33rd day,
Which is, do we know?
which is 10/20, so tomorrow, if an information is not filed. I did speak to the ASA and she intends that it will be filed today, if not tomorrow.
You think it will be?
She intends for it to be, yes.
You ever just roll these?
That's
I don't
been
care. I
the
mean,
argument,
however you
likely.
want to do it.
This is a private defense attorney one, so.
I've
it
half
can be
written it
rolled.
out.
You can go ahead and write it out, I mean, as long as he's not released until tomorrow.
Defendant to be released on
10/20/22,
10/20.
if an information is not filed.
If no information has been filed. Okey doke. All right, and that's it?
Yes,
We're
sir.
adjourned.